Judges Tandazwa Ndita, Robert Henny and Mark Scher have urged throughout that mediation would have been and still is the best option. The bench warned that the court matter could have far-reaching implications. The main applicant, Professor Adam Mendelsohn, was represented by Advocate Edward Fagan. During rebuttal, following the conclusion of main arguments, Fagan told the court that the failure to investigate the adverse negative impact and the decision not to mitigate the fallout was irrational.
UCT was not deciding between stopping a genocide and losing funding. Those weren't the alternatives here. It accepts that the resolutions would have no impact whatsoever on the war in Gaza. It was making a reputational decision. So it undoubtedly needed to consider whether the resolutions would make UCT better or sicker, and if sicker, then by how much.
Fagan told the court the UCT council members and its chair, Advocate Norman Arendse, withheld information about the far-reaching implications.
And it's not rational to recognize that there will be adverse impacts, as the chair testifies. There will be adverse impacts, and then to proceed to make a decision without knowing anything at all about those impacts, including, as I said in opening, the order of magnitude of the loss of financial support, how many students would lose funding, 200, which we know just from the Dell Foundation was 288, just from the Dell Foundation, and how many research projects would have to be terminated and how many staff members would have to be retrenched.
Representing both the UCT Council and the University, Advocate Tembeka Ngqokatobe argued, amongst others, that no information was deliberately concealed, including the possible fallout. Reading from the record of the council meeting, he told the court there were discussions around the issue.
Now, what they decided, and I read the line yesterday at page 182, I read the line from Speaker 13, who says that we will be condemned morally if in this case, where there is such urgency, we did not pass the resolution. And he says, I know that there will be financial consequences, but despite that, we must pass the resolution. Now, your Lordship might say, I don't think they should have done that. But your Lordship is then straying into the realm that really belongs to the Council as a policy maker.
The court also heard that the resolution still has to be implemented and that it had been referred to the Senate to formulate rules.
The executive is required to develop the guidelines required for enforcing the resolutions. Therefore, until the guidelines are in place, no sanctions can be applied. However, as a policy framework, the IDF resolution remains a powerful moral statement signifying the position of UCT on one of the most urgent moral questions of the day.
The South African Jewish Board of Deputies applied to be a friend of the court, expressing concern over the impact of the resolution. It also alleged there is growing hostility on the campus.
A lot of the issues around this court case are around how Jewish academics and Jewish students are being treated on the university campus. And what's really been worrying for us is how incredibly hostile the campus has become. We've seen incidents of anti-Semitism arising. We've seen intimidation and threats to Jewish academics on the campus. And although the case is a technical case and a procedural case, we feel that it's very important that the way Jews are feeling on the university campus needs to be included in the discussion in the court.
At the start of the litigation, a number of organizations, including the Palestine Solidarity Campaign, participated in protests outside the court. South African Jews for a Free Palestine also applied to be a friend of the court. Advocate Jeffrey Budlander for the organization told the court, among others, that the South African Jewish Board of Deputies is not the definitive representative body for all Jewish people.
But it doesn't represent South African Jews. It doesn't represent South African Jews who are members of Jewish organizations which haven't affiliated to it. It doesn't speak for them. It doesn't represent South African Jews who are not members of Jewish organizations at all, so-called unaffiliated. doesn't represent them. It only represents the members of organisations which have affiliated to the Board of Deputies. The claim is simply false and it needs to be rebutted.
He added that the South African Jewish community is vibrant and diverse, with many varied stances that are not necessarily aligned with that of the board.
The claims that the Board of Deputies makes is it's really time for that to stop. To stand up and say we speak for all South African Jews, it simply is not true. If I can get personal, they certainly don't speak for me.
Ngukatobe was allowed to submit written notes on what he told the court are 7 inaccuracies in the main applicant's rebuttal. It's unclear at this stage when judgment will be delivered. Mariska Botha, SABC News, Cape Town.